Assistant Public Defender Sandra White on behalf of George Turner.
George Turner.
Hello, Mr. Turner.
Yeah.
So you're here for sentencing on a violation of probation?
Yes, Your Honor.
Have you had a chance to go over the report with your client?
I have, Your Honor, and we ask that you accept the recommendation.
All right. So are you going to continue with your reporting? You need to get a new assessment done. Pay your fines and costs. And I'll see you back in 60 days. Well, actually, I'm going to make it a little bit longer. Anything between July 25th and August 22nd.
August 8th.
All right, I'll see you on August 8th. Okay, sir?
All right, and I got one question for the assessment. Do I call probation for that?
You community corrections should be able to do that assessment for you. Have their phone number, right?
Yes.
All right, call community corrections. There needs to be a new referral, I think, though. So can you? Well, I'll have you call Ms. Johnson first or email her to remind her to do the referral to the CCLP, because if the referral's not there, they may not do it. So, and she's not
Oh,
here today. Okay.
all right.
Okay. I'll also put a note in this file for that too. So talk to Ms. Johnson and then just to community corrections.
All right.
All right. Thank you, sir. Good luck to you.
Yeah, thank you.
You're welcome.
Your Honor, what type of hearing will that be on August 8th? Will that be the sentencing that's adjourned?
This is the sentencing. He'll be back for review on that date.
Thank you.
State of Michigan versus Devin Gisandiner, case number 24 FB 1016.
Richmond, Deputy for the People.
Assistant Public Defender Sandra White on behalf of Devin Gisandiner.
So much better.
If you can state your name for the record.
Devin Gisandiner.
Thank you, Mr. Gisandiner. We're here for sentencing today. Have you had a chance to go over the report with your client?
I have, Your Honor, and there are some items that Mr. Gisandiner would like me to add to the report.
All right, thank you. You may proceed.
Okay. He wants the court to know that the firearm was registered. And under the financial situation, his monthly expenses are now $2,500. I think it stated $1,500.
How did it go up that much?
He now, you're paying for a home now or rent, is that correct?
Yes, a new apartment.
New apartment.
Okay.
And he wants to update or add to his physical health.
All right.
He has a tendon transfer, a total left knee reconstruction, spinal cord stimulator.
Wait one moment.
Okay.
You say left knee?
Yes, left knee reconstruction.
Okay.
Spinal cord stimulator. And a collarbone titanium plated.
He's a bionic man. You got a lot going on there, sir.
It's from a car accident in 2018.
Oh,
My left arm and my left leg are about 60% paralyzed.
oh, I'm sorry.
So, stuff happens.
And I believe at the beginning of the summary, he wanted to say that he had stopped the interview because he had he had heard the wrong charge stated at the beginning of the interview. So he has stopped it to consult with the attorney.
Oh, I see. Okay.
And then once we the 2 days later, once we had the actual interview, the probation officer I had the interview with, stated that I was correct. I'm not sure what she was looking at, but I was correct that, and so we were able to move forward with the interview with no problems at all, just as if normal.
All right. Thank you, sir.
Mm-hmm.
That's everything, Your Honor. Thank you.
Any objections to those additions, Ms. McDuffie?
No objection.
All right. Anything from the people?
One moment. Sorry about that. I agree with the recommendation. The only thing that threw me off was just the reference to Mr. Gissendaner saying that the officer was confused about who it was that ran the stop sign, and that it was I just that just insight is always like a big deal for me, and so that little detail just kind of stood out, and it was a little bit odd to me because I don't see how it would happen that an officer would be confused about which car did what. The report clearly identifies his vehicle. That's not super important. I think with respect to this case and the circumstances, it looks like Mr. Gissendaner was forthcoming about the details of not having a proper CPL and transportation of that weapon. And so I don't have any huge concerns about him. That just threw me off a bit. But other than that, I agree with the recommendation, and I appreciate Mr. Gissendaner owning his actions as it relates to the core of this incident.
Thank you. Anything you want to say in terms of allocution on behalf of your client, Ms. White?
Basically, Ms. McDuffie summed up what I was going to say. So nothing else. I don't know if Mr. Gissendaner wants to say anything.
Anything from you two?
I sure. I mean, shoot. I mean, I could explain my real confusion with what had went down initially, with the initial stop. So I had made a complete stop at the stop sign, and the person in front of me blew through the stop sign. I didn't think that it was my responsibility to wait for somebody else's turn if I had been the first one to make a legal stop. Uh, but after a couple, what do you call it? Probable cause hearings, it has come to my attention that regardless of whether or not the person in front of me uh, made a legal or a full stop, which they did neither. It would still be my responsibility to have the intersection clear before I went, regardless of whether or not I legally stopped first. So they had decided at the end of it all that the officer did have probable cause to conduct an investigation at that time, regardless of whether or not I made a legal stop. I was just asking a million different people what happened. Why did I get pulled over when I stopped first? And I went first because I stopped first. But the reason is because uh, it was, they said it was my responsibility to wait until the intersection would have been uh, clear, I think.
I see. All right. Thank you for that explanation. I'm going to try to decipher it all, but the bottom line is you understand at this point that you had an obligation to make sure that the intersection was clear before you.
Yes, I understand.
Okay. All right. Thank you. All right. I find that the recommendation is fair as well, and I'm going to follow the recommendation. Sir, you are to serve 90 days in the Washington County Jail, credit for 3 served. The balance of that is suspended. As long as you complete these requirements, which aren't many, then you won't ever have to do any jail time, additional jail time. Okay.
Mm-hmm.
So $525 in fines and costs. The weapon is forfeited. Complete the gun safety class and complete 5 hours of community service, and then come back here in 60 days on July 25th, 2024 at 10 o'clock. If you have all those things done, then this case will be closed out. Is he on the deferred or anything, or is this just a straight?
What was the question?
I was wondering if this was a deferred sentence in any way, or if this was just a straight plea.
I think it's just a straight plea.
Okay. All right. Thank you. You're all set. You need to contact the probation department tomorrow after 9 o'clock a.m. in order to sign your contract with them to complete. It says no delayed or deferred. So yes, this is straight plea. So in order to sign your contract with them. Okay.
Visit probation tomorrow.
Call them. Do you have their phone number? I'm going to give it to you right now.
I would love it if you could give it to me right now. Let me get my
pen. Take your time.
Yeah.
Anybody else on the call that might get referred, please get a pen ready and be ready to
I got my
write down.
pen.
734-483-7336.
7336.
Correct.
And Your Honor, I'm sorry, you said your notes show no delayed or deferred?
Yes. It's
Okay.
on the signed plea form.
Oh, my plea form is silent, but it's not completely signed. It's only signed by the APA. So there must have been an updated one.
Okay, because this one's signed by the prosecutor and it's typed in there where it says defendant, attorney, and then the judge has signed it, and it is right next to the date, April 16th, where it says no delayed or deferred.
Oh, this is February. So this is probably an earlier one and date. Okay. Thank you.
All right. Thank you. You're all set, sir. Have a good day.
Thank you. You too.
State of Michigan versus Michael Foley, case number 22S00964.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Michael Foley.
Michael Foley.
Thank you. Good morning, Mr. Foley.
Good morning.
Mr. Foley is here for a review. He's supposed to have an assessment done by today's date at GrowthWorks. I extended his probation on April 4th. Ms. Straub, do you have any update on this particular file? I thought I saw a report. Michael Foley. Okay. Does anyone have a report on this one?
I believe I saw an email from Ms. White, but I don't know if let me see here.
Yes, we have a report.
Yeah, I thought I saw
it. I see it. It's bundled in with a couple other cases.
I'm pulling it up right now, Your Honor. I don't have it right in front of me.
one moment. I have it, apparently.
So the only change to the report that you have, Your Honor, is I do have community service completion.
Okay.
His assessment he did complete. He was not recommended for treatment at this time.
Thank you.
So he just has fines and costs, Your Honor, left.
Okay. Sherwood, can you play off your fines and costs?
Say that again, Your Honor. I'm sorry.
When will you be able to pay off your fines and costs, Mr.
So I have a set payment plan in mind. My first payment is going to be 150 on the 29th with my first check. And then the plan was to do $100 a month after that. I just got back to work off a pretty long layoff. So So I've only been to work for about a month now. If it needs to be sooner, it can be, but that's the set plan as of right now, was to do 150 on the 29th and then $100 a month after that.
Mhm. When is he technically out for probation?
Your Honor, his probation was just extended in April for 6 months, so he's not technically set to expire until October of this year.
All right, so what I'll do is bring you back in August to see if you're making your payment plan. You said, one moment, let me get my correct piece of paper to be able to jot down your plan accurately. 1 second. You say you're going to make the first payment of how much, sir?
$150 on the 29th.
And then you're going to pay $100 a month on what day of the month again?
We just agreed on a month. It was going to be probably my next paycheck. I didn't pick a day at the
All
time.
right. So we need to pick a day of the month. Every month is going to be the same. You can pay it before or before then.
Yeah. I guess just let's do the 17th, I guess. I don't know.
Okay.
I'm just picking a random day in the
That's
middle of the
fine.
month.
All right, 17th, $100. So I'll see you back here on August 22nd and see if you're making those payments.
If I am able to pay it off sooner, Your Honor, as I get working, am I able to get off sooner if that's the case?
Yes, you are, sir.
Oh, okay. Yes, ma'am.
All right. So I'll schedule it for August 22nd. If you're all paid off by then, we'll just discharge you and you'll be done here. Okay?
If I'm paid off by then, do I still show up on August 22nd, or do I not need to show up then?
Talk to Ms. Straub and she can confirm whether or not you need to show up. Okay?
Yes, ma'am. Yes,
All
ma'am.
right. But typically, if you're just doing payments, you wouldn't have to, but you're still on probation also.
Yes.
So that's the reason why you may still have to show up. Okay?
Yes, ma'am. Yes, ma'am.
Thank you. You're all set. Thank you for taking care of that. Take care of yourself, Mr. Foley.
You too.
Hold on one moment, please. State of Michigan versus Christopher Hurst, case number 23FB1275.
Rachel McDuffie for the people.
Christopher Hurst.
Thank you. All right, Mr. Hurst had Mr. Drukas last time he was here. And and Mr. Jukis is no longer on this case. It looks like Mr. Hurst has done the DV weekend program with accountable choices, and he needs to be completing his 52 sessions as recommended and start making payments towards his fees. Do you understand those things, Mr. Hurst?
Yes.
Where are you with starting those 52 sessions, sir?
Oh, I've been going.
You've been going? How many do you have done yet?
I'm on my fourth assignment still.
Okay.
Like some weeks or whatever, I'm still working on it. Like it probably takes me 2 weeks for every assignment because I have to get people in the class to
Okay.
approve it. And
Well, it sounds like you're doing what you're supposed to be doing. That's good to
I'm
know.
definitely doing what I'm supposed to be doing.
All right,
And
good.
on my payments, I think I only have $600 left out of the 1,200 it was. I'm also going to be making another payment later today. So
Oh, okay. Good job, sir. Thank you for doing what you're supposed to be doing. I'll see you back in 90 days. Hopefully you still are, if you're still on track.
my payments should be. I should have all my fines paid up within the next two months.
Okay. If you're still doing as well as you're doing right now, I may excuse you from having to appear here. Okay.
Okay.
I'll let the probation agent determine that, but I'm writing that you may be excused if still compliant. Okay. Your next court date is going to be on August 22nd, 2024 at 10 o'clock a.m.
Okay. Thank you.
Thank you. Have a good day, sir.
You too. Bye.
Bye-bye. All right, the court will recall the matter of the state of Michigan versus Robert Hayes, case number 23 FB 1489.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Robert Hayes. Mr. Hayes, can you state your name again?
Yes, Robert Lee Hayes Jr.
Thank you. All right, what would your client like to do with respect to the bond violations?
He would like to admit to those violations, Your Honor.
Thank you. Sir, please raise your right hand to be sworn. Do you, other right?
I'm
please.
sorry, ma'am. Sorry.
That's okay. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may lower your hand. Sir, is it true that you tested positive for alcohol on January the 13th at 8:51 a.m. and then you failed to reblow in the machine as was ordered and that you've missed multiple tests while being on the sober link?
Yes, ma'am.
All right. I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Thank you. Ms. White?
Yes, satisfied, Your Honor. Sorry about that.
It's okay. All right. So what are you requesting today with respect to Mr. Hayes, Ms. McDuffie?
Your Honor, I agree that he needs to be, that's the trouble with assessments, right? Is that they depend on the person being honest and it's unclear how to move forward from there if they aren't honest with themselves enough to be honest with somebody else. I agree that he does need to get assessed and be honest. But given that we have these violations too, this compounds that because I'm not sure if he obviously addressed those things with the assessor as well. So I guess I would have to ask the court to let's see what the next assessment says. And if it's apparent that Mr. Hayes is still lacking insight and not really being truthful with himself and everyone else about where he is with this issue, then I think we should discuss potential sentences that reflect that.
Well, Mr. Hayes, I think to cut to the chase, what she's saying is if you don't get this right, if you don't come clean and basically fess up to everything that's going on at this point in time, you're going to be spending some time in jail. Do you understand that, sir?
I do, ma'am.
So we don't want to, I don't want to. She can't even say it, so I know she really doesn't want to put people in jail. So the reality is that we don't want to put you in jail. But if you don't do what's necessary to try to get the treatment you need for whatever's going on with you, then that's where we'll have to put you to protect you from society, protect society from you. Do you understand that?
I do.
Okay. So we're going to re-refer you one more time. You need to figure out how to become completely honest with this assessor so we can get you the proper treatment. And we'll come back and try this again. And in addition to that, you must not have any additional violations on this sober link. If you do, then I'm going to have to issue a bench warrant immediately because they're going to send a report over to me that you have, and then I'll just issue a bench warrant before that time. So if you need some assistance before then, you should tell us now so we know that right now so you don't go to jail. Do you think you can do this?
Yes, ma'am.
Okay. All right.
Ms. Washington, as far as with the resubmitting this assessment, would it be an additional fee?
Ms. Straub, are you present? I don't know if there's another fee for you to get reassessed. It shouldn't be the same amount, but I don't know. Ms. Straub, do you know if she charges?
I'm not sure. I know it's not the full amount. I think it's honestly a case-by-case basis, Your Honor.
Okay. All right. Is that going to be a problem for you, sir?
It should not be. I was told that it would probably be the $60
No, that's
like
a
the late fee.
re-referral. That's a re-referral fee
Right.
for the court. That's not what the assessor does. I'm not sure what the assessor does.
Okay.
And that $60 fee, you don't have to pay up front or anything. My concern is whether you have the money to pay the assessor's fee up front, and I don't know what that number is. If you have an issue, please call Ms. Straub as soon as possible so we can know. Okay, once you talk to the assessor.
Okay.
About it. Okay.
Okay.
All right, I'm just writing myself some notes here. Give me one moment.
Okay.
I'm going to bring you back on June 27th, 2024 at 10 o'clock a.m., sir. Please have that honest assessment done, and we'll see what she says and what we can get you in terms of resources to try to help with what's going on. Okay?
Okay.
All right. Thank you, sir. Your
Thank
bond
you.
is continued. All right.
Thank you.
Bye-bye.
Have a great day.
You too. Bye-bye. State of Michigan versus Megan LeBlanc, 21S00232.
Rachel McDuffie for the people.
Assistant Public Defender Davi Liba for Ms. LeBlanc. Ms. LeBlanc, could you unmute to state your name, ma'am?
Ms. LeBlanc, please. I don't even think she's here anymore. She's gone. Wait, she's coming right in. All right, I'm going to pass that. I'm going to deal with Ms. Farkas's matter while she gets reconnected. State of Michigan versus Francis Farkas, case number 23S00481.
Assistant Public Defender Davi Liba for Ms. Farkas.
And Rachel McDuffie for the people.
Farkas?
Yes, Francis Farkas. Sorry, I had to unmute. I had to come here.
All right, thank you, Ms. Farkas. Ms. Farkas apparently missed her Zoom pre-sentence interview appointment for May 15th.
That is correct, Your Honor. I've discussed with Ms. Farkas. It seems that she's mixed up the times for that. She's assured me that that will not happen again.
Ms. Farkas,
Yes.
I'm gonna reschedule it for you. I'm gonna reschedule your sentencing, and you need to keep this appointment with the probation department this time, okay?
Schedule it when?
June 27th.
I'm sorry, you're fluttering.
June 27th at 10 a.m. ma'am. That's for your sentencing, not your. You have to call probation to schedule the interview time, ma'am.
June 27th at what time, ma'am?
10 a.m.
Okay, thank you.
Thank you. Bond is continued.
Thank you.
The re-referral fee is under advisement. I'll figure out whether I'm going to do that at the time of sentencing. We'll see how this goes.
Okay, thank you. I don't know how to turn this off.
We'll get you, ma'am. We got it. Thank you. All right, the court will recall the matter of the state of Michigan versus Megan LeBlanc, 21S00232.
Rachel McDuffie for the people.
Assistant Public Defender Don Lieb on behalf of Ms. LeBlanc. Ms. LeBlanc, if you could start your video and state your name, ma'am.
I'm trying to start my video. It's telling me I'm unable to access my camera.
Where is Miss LeBlanc right now?
I am at McDonald's sitting in the parking lot. We don't have Wi-Fi at my house, so I had to have Wi-Fi to be able to Zoom. So I'm sitting in the parking lot at McDonald's right now.
Okay. What is going on with Miss LeBlanc? Because we don't have the treatment update, the substance abuse evaluation, or any other information. We can't even see her at this point. What is happening?
Ms. LeBlanc encountered some technical issues when she tried to submit the paperwork to the 34th District Court Recovery Court program. So we're going to be requesting an adjournment for to complete that. She did send me some documentation that she completed yesterday, she recompleted yesterday. And I have left a message for Shannon Rapp, who is the treatment court coordinator. So we can hopefully get that process moving to be ready at the next sentencing date.
Ms. McDuffie.
Nothing for the people. Except that Ms. LeBlanc should plan to come to the court's Zoom access point probably next time.
Well, I want to see her in person, so
Okay.
I can resolve that. How long do you need, Mr. Lebo?
Your Honor, if we could get 60 days, I think that would be very helpful. I've had a little bit of trouble getting return phone calls from the 31st District Court Recovery Court program. So I want to account for the fact they may have some difficulty returning phone calls quickly.
Is Ms. LeBlanc testing?
Yes, ma'am. Only thing that has showed up in my test is I've been positive for THC, and I did give a copy of my medical card to my probation officer.
Ms. Straub, are you present?
I am, Your Honor.
Are you able to confirm that she's been testing and they are showing nothing but THC?
She has been testing. She's missed a couple of tests, but when she does test, she is only positive for THC. Although she hasn't, I'm not sure what was ordered, but it doesn't look like there's been any ETG tests, just PBTs.
I'll adjourn it to July 11th. There's no. Oh, I see.
I'm sorry, Your Honor, but I guess I'm a little bit unclear. So regarding this recovery court issue, Ms. LeBlanc's issue the entire time our case was pending, including when she was here in earlier years before she was out on the bench warrant, was that she was being referred for a court in Wayne County because she's not a Washington resident. Is that something that's changed in the last few weeks? And is she now eligible for our recovery court?
No, it's 34th District Court.
Oh, you say I didn't hear the 34th part. Okay, thank you.
I'm gonna adjourn this to July the 11th
At what time, ma'am?
at 10 o'clock, at 11 o'clock a.m. in person.
And may I say you look very nice today, Your Honor.
Well, thank you, Ms. LeBlanc. I appreciate that. Your bond is continued. I'll see you then, okay?
All right. Have a good day.
You.
Thank you. And Ms. LeBlanc, please call me if you need any help with that paperwork, okay?
All right. Thank you.
All right, the court will be on a brief recess. All right, the 14B District Court is back in session. Maybe no one else is here. The court will call the case of the state of Michigan versus Gary Schott, case number 22-00837.
Rachel McDuffie for the people.
Good morning, I'm Michael Barnicki for the defendant who's here with me.
Thank you. Good morning. All right, today's the day and time scheduled for an opinion from the court with respect to this matter. I have had a chance to review the briefs that were presented in this case. Mr. Barnicki, it is your motion. Do you want to make any arguments before I hear from the prosecutor?
I don't think so, Your Honor. I think I read my brief again today. I think I outlined everything pretty well, so I just don't want to repeat anything.
All right, thank you. Ms. McDuffie?
Your Honor, so following the hearing that we held in person some time ago, my understanding is that the court really just had a single very specific question. So I did not reopen all the previous arguments. I think those things had kind of been discussed. And I know we were waiting the ruling on those, but the central issue was whether there was any potential for Mr. Schott's, any potential for the fact that because Mr. Schott appeared to not want to comply with the request that he was getting for his glasses to be removed, how that might affect the case. And so I explained that in my response in terms of the fact that Miranda just simply does not apply in this context. I shouldn't say doesn't apply in any context, but with respect to traffic stops and Terry stops of this nature, as the court mentioned, the court question, is this something different than a field sobriety test where an officer can make requests and ask questions and solicit responses? And that's not something that would fall under that. And the court's, I think, intuition on that was absolutely correct, which is that Miranda, those sorts of issues don't apply here. So my response to the court's question is that that's not an issue that, number one, should really affect the outcome of this hearing nor the case. If there had been a Miranda issue, I explained that further, providing citations and I think some of 2 cases in full, which explained that there is a point where Miranda or the failure to advise someone to Mirandize someone can apply when that person is essentially handcuffed. They're clearly not free to leave at that point, and that creates a different context and an environment in the situation where statements could be suppressed. And it is only statements. There is no provision for suppressing actual evidence from a case, even based on that, had there been a violation. It's the people's position, however, that there was no violation in this case.
All right, thank you. The court did hear and from the officer take testimony regarding and watch video actually regarding this particular stop. This is an unusual situation in which the son of the defendant was seeking to have a car that they both were shared leaseholders on returned to him after the son had had the vehicle taken back from him while it was at a friend's house. There's this started out as a civil standby, whereby the police officers were initially going to go to the father, the defendant in this case, Mr. Gary Schott's home, and try to retrieve some belongings that the son indicated were inside of that particular vehicle. As they were driving to that home, the defendant passed by the parties going in the opposite direction. I believe that at the time, the officers were not aware that it was the defendant who had passed, but once they arrived at the home, the son advised that his father had simply passed by them and that he believed that he was probably still under the influence of alcohol from drinking from the night before. The officers then turned to go back to the gas station, where they turned to follow the defendant, and they found him at a gas station. And the officer abruptly turns into the gas station, sort of, at least his back tire hitting the curb and making a jostling of the officer within the car, which we could see from the video, giving the court the impression that maybe at that time he appeared to have come in so abruptly that someone would be concerned about what was going on. in this case, that someone that I'm concerned about would be Mr. Gary Schock and what his thoughts were as to the officer. The officer approached Mr. Schock at that point in time fairly aggressively, is my opinion of what happened, and advised him that he needed to see his license and had a discussion with him. I believe the prosecutor adequately outlined what that discussion was and the nature of the conversation as far as what the transaction was between the parties. This court was concerned because at some point in time, Mr. Schock was basically told that he needed to remove his sunglasses. And it was at that point that I believe the officer definitively believed that Mr. Schock was under the influence. And prior to then, he had suspicions. And as I read through both the defense as well as the prosecutor's briefs in this case, I have to agree with the prosecution in this case. Although this started out as a civil matter, the officer does not have any obligation. And in fact, he has an obligation to do the opposite. He can't turn the blind eye when he sees that there is a clear violation of the law going on. And the officer indicates, and I believe it's an issue for the trier of fact, that he actually witnessed Mr. Schock driving at one point in time. He wasn't driving at that time. Mr. Schock's position was that I'm not driving right now. You could arrest me potentially for being drunk in public, but not for driving. It's more convoluted than that, and there are more details than that, but that is what the bottom line is. The officer felt as though Mr. Schock was under the influence and had witnessed him driving a vehicle. And at that point in time, I believe as an officer, he has an obligation to follow through on whether or not Mr. Schock is driving. At that point in time, I think it turns into your standard stop with the field sobriety situation where the officer has the ability to ask questions without Mirandizing. Field sobriety stops are very different than any other stop. And that's just my assessment of where we are. For those reasons, I'm going to allow the case to continue and nothing will be suppressed. So, and you are free to file whatever motions you want to file. Sometimes courts are wrong and I can accept that maybe I am, but that is where I am with this particular matter. Okay, and I have taken a very detailed look at it. That's just what my position is.
All right, thank you, Your Honor.
Thank you.
Are we going to get a pretrial date today, or?
Yes, I'll give you a pretrial date. Does June 20th or June 27th work better for your calendar, Mr. Bartnicki?
June 20th is fine. Is that good for you? Sooner than later.
Pretrial will be June 20th, 2024 at 9 a.m. Bond is continued.
Will that be in person?
No, it's Zoom.
Okay. All right. Thank you.
You're welcome. All right, the court will call the case of the state of Michigan versus Kristen Moose, 24S00151.
Pray to me, Deputy for the people.
Good morning, Your Honor. Tina Saxon on behalf of Kristen Moose.
Thank you. Where's Ms. Moose?
Your Honor, my notice was to the hospital. She had been released. She's calling me right now. May we pass so she can log in?
Certainly.
Thank you.
Yeah, we can get started. Are we going to get set up for our in-person hearings at this time? We'll be on a brief recess.
We are unmuted on the Polycom now, Your Honor. We are on the record as well.
All right, the court will recall the case of the state of Michigan versus Kristen Moose, case number 24-00151.
Rachel McDuffie for the people.
Tina Saxon for Miss Moose, and I have Miss Moose on my phone, and I've confirmed her identity. Kristen, please state your full name for the court.
Kristen Moose. I thought Miss Moose was signing in.
Yeah, and I sent a chat message to the your host. She's having technical difficulties logging in via Zoom. So if it would please the court, I'll ask for an adjournment.
Miss Moose needs to turn herself in. Why is she not turning herself in?
Why is she not turning herself in?
Correct.
She was released from the jail, which is in my motion. I'm sorry?
I know she was released erroneously.
Okay. And so I filed the motion and not hearing that she had to turn herself back in until just now. What time do you want her at the jail by, Your Honor?
Miss Moose needs to turn herself in immediately. She was never supposed to be released. She told me she was going into treatment, and why is she not in treatment?
She went to the hospital, Your Honor, and that was the information that I sent as exhibits, that she was in the hospital, showing that she was admitted and had the date. And then she was tentative.
Released from the hospital?
Miss Miss, when were you released? I know it was tentatively Thursday.
I gave you the documentation.
I didn't. When were you released?
I think it was 4 days ago.
So she was released 4 days ago. Why is she not in treatment though?
Your Honor, I did not know that she was supposed to go into treatment, to tell you the truth.
No, that was not documentation.
Miss Moose, stop. I can't hear the judge. Your Honor, I just knew that she went into the hospital. I'm not on her other case, so I'm not sure what is happening there. I just know when she was released, she had been having medical problems that she did tell me about once I got appointed to her case. Then this release happened. She was at U of M. I confirmed that, sent the documentation. If there was an order from Judge Simpson on the other case for her to go into treatment, I was not made aware of that.
The order was from this court from day one that she be released to treatment. And she told me that she was going to be going into treatment when she was here the last day before they released her erroneously.
Okay, I'm sorry, Your Honor. I did not know that because I'm not on that case.
It's this case. Ms. Saxon, you were here.
There was no discussion about her going into treatment on my case. We set another date.
Yes, there was.
Your Honor, I honestly do not recall hearing anything about treatment because of the case I have her for. I had mentioned that she had the other case, and that date for sentencing is June 20th. And then we set the date on my case for June 4th to come back.
They never did. They never said that. You're right.
Stop. So I don't even have notes about her going into treatment. It was all pending for sentencing.
Ms. McDuffie, do you have anything on this case?
Your Honor, my notes show on May 13th that Ms. Moose was arraigned on the bond violation, that violation being her having cut the tether off, obviously. She was in custody at that time. And that Ms. Saxon, who had just been appointed at that time, needed to submit an appearance to get discovery. And we adjourned to June 3rd. I don't have any other notes. I know traditionally when somebody is in custody, especially with the type of substance abuse problems that Ms. Moose has, that they are often permitted to be released only to treatment, but I don't have any specific notes with a reference to that.
Oh, okay. I need to speak up. They let me out on Tether, on Scram, and GPS.
We're aware of that, Ms. Moose. I would suggest you take your counsel's advice to not say anything further.
Your Honor, I've been on Tether. I've been in my home.
Miss Moose,
Yes.
allow the judge to talk. Stop talking.
Ms. Moose was on a 50,000 10% bond to this court, and the jail erroneously let her out for some reason or another. Ms. Moose was called by the jail. Ms. Moose was called by the jail per information I received and told to return to the jail. She told them she was going to return the next day, and she did not show up.
Understood, Your Honor. I was not aware. So, Ms. Moose, turn yourself in immediately.
Okay.
Thank you, Your Honor.
Thank you.
Thank you, Mr. McDuffie.
Are these all in person? Yes. Okay. Do we have some failure to appear so we can have it from the Miss White is still talking to the in-person, so we'll handle some failure to appear while she does that. I will call the matters of Simon Burgeon, case numbers 20FB1427 and 20S00213.
Rachel McDuffie for the people.
Simon Burgeon is supposed to be here for a show cause hearing today. Simon Burgeon did appear at the last hearing. Have any payments been made? 1 moment, please. I don't know if you've had a chance to look, Ms. McDuffie. Have any payments? Is anybody here from the PD's office for Ms. Burgeon? This is a PD case. Or Mr. Burgeon, I'm not sure which it is.
Your Honor, could I get the case number, please?
Two cases, 20FB1427 as well as 00213.
And I don't see any payments from them.
Thank you, Ms. McDuffie.
My notes indicate that he told Ms. Moeller that he intended to come to court this afternoon to make a payment.
Defendants failed to appear and failed to pay. Show cause in this matter will be June 27th, 2024 at 10 a.m. State of Michigan versus Justin DeMond, case number 23FB1013.
Assistant Public Defender Davi Lebo for Mr. DeMond. I have not been able to have any contact with Mr. DeMond.
Defendant has failed to show up for his PSI appointment as well. This is an assaultive matter. Anything from the people?
Given that, Your Honor, we will request a bench warrant.
Judge warrant to issue in the amount of $20,000 cash or surety. No, actually, I'm gonna do 10%. State of Michigan versus Dennis Duff, case number 23S00246.
Richmond, for people.
Assistant Public Defender Davi Lebo for Mr. Duff. Your Honor, I have not been able to contact Mr. Duff. We did leave him a voicemail and sent him a text.
Mr. Duff didn't show up for the last court date either on April 4th. And we have received no documentation regarding him allegedly going to the hospital. Anything from the people?
Your Honor, given that, I would request to be sworn in this case as well.
Bench warrant to issue, no bond. One moment, please. State of Michigan versus Kevin Hayes, case number 21FB1673.
Richmond, Justice for the people.
Assistant Public Defender Davi Lebo for Mr. Hayes. We have not had contact with Mr. Hayes.
Has he made any payments?
He has not, Your Honor.
Defendant failed to appear, failed to pay. Show cause June 27th, 2024 at 10 a.m.
Your Honor, it looks like his last one was a show cause as well in February. Is that correct?
I think he was here, and that's when he set up his payment plan for $100 per month on the 15th of each month. Correct.
Oh, that's right. He was on that other case. Thank you.
State of Michigan versus Miller needs Miller, case numbers 19S00148 as well as 19S00168.
Richmond, Justice for the people.
Assistant Public Defender Davi Lebo for Ms. Miller. We have had contact with Ms. Miller, and my understanding was that she would be in court today.
Well, she didn't show up last time either. Has she paid anything?
I have not been able to check into that myself, Your Honor, as my GIS is not working right now.
It appears she has made no payments. And it's failed to appear, failed to pay again. Bench warrant issued.
Would you like to start? I'm going to start with the 148 case. That one is 1470.
Bench warrant to issue in the amount of 5,000, 10%. And case number 19S00148. 5,000, 10% in each case. State of Michigan versus Prentice Metz, case number 23FB1167.
Richmond, Justice for the people.
Assistant Public Defender Dobby Lebo for Mr. Mintz. We have left a voicemail for Mr. Mintz, however, it does not appear that we've heard back.
So he's due our probation on July 26th. Apparently he completed his crosswords program and he's reporting like he's supposed to be. The only thing he is not doing is making payments, and he showed up at each of his court dates before. Supposed to be here for review. Anything from the people on this one?
No objection to show cause. Mr. Mintz became compliant after being completely non-compliant. So, and I think as the court mentioned, he had showed up before.
Set a show cause for well, just to make sure that we can get it back on track with his payments. I set that for June 27th at 10. State of Michigan versus James Robinson, case number 21-00031.
Rachel McDuffie for the people.
Assistant Public Defender Dobby Lebo for Mr. Robinson. I have not had contact with Mr. Robinson. I did leave a message, and it does not appear that he has made payments.
He was here on March 21st, 2024, which time he set up his plan to. He told me he could pay $200 a month. Defendant failed to appear, failed to pay. I'm going to do a show cause. June 27th, July 25th. I'll do it on July 11th, 2024 at 10.